It is good that most people will never have their daily lives disrupted by a serious crime. However, the few who do often find themselves unfamiliar with the nuances of the legal system. That can frustrate and confuse victims. It can have the same effect on everyday citizens who are simply trying to understand the procedures in a high-profile case. Welcome. My name is Jeff Kidd, and I'm the Administrative Chief of Staff at the 14th Circuit Solicitor's Office. We bring to you this video series to explain the criminal justice process in the 14th Circuit and to make the confusing clear. In this fifth episode, we explain how bond is set in South Carolina's General Sessions Court cases. Once a criminal charge is forwarded to our office from law enforcement, our attorneys follow a pre-indictment checklist that helps them determine whether a case is suitable for prosecution. This process is thorough and can take a substantial amount of time to complete. For instance, to await results of forensic analysis such as a DNA, ballistics, or gunshot residue test. However, time does not stand still for a defendant's rights. In most circumstances, the accused is entitled to a bond hearing within 24 hours of arrest. At a bond hearing, our attorneys will make an argument based on what they know at the time about the facts of the case and the defendant's criminal history. However, it is not up to the solicitor's office to determine whether bond will be granted or the amount necessary to secure release if it is. This is left up to the judge. At a bond hearing, defendants are not expected to enter a plea or file motions. In American jurisprudence, bond is not used as punishment. In fact, state law requires the release of every defendant on his or her own personal recognizance pending trial, unless the judge determines the defendant is a flight risk or a threat to public safety. A judge has several options. He or she can deny bond, set a bond amount, and also attach conditions to bond. For instance, placing the person in the custody of a designated person or organization that agrees to supervise the defendant. Placing restrictions on the defendant's travel and associations with other people, such as victims, witnesses, or people with known criminal affiliations. Imposing any other condition deemed necessary to assure the defendant shows up for court as required. These conditions can include electronic monitoring, house arrest, a curfew, or a requirement that the defendant return to custody after specified hours. There are several types of bonds. A personal recognizance bond releases the defendant from custody without paying anything. However, the defendant must sign a written promise to appear in court on the scheduled date. This type of bail is typically reserved for nonviolent offenses and first-time offenders. A cash bond requires the defendant to pay the full amount of bail in cash or with a cashier's check. This is typically required for more serious offenses, and the amount of bail can be quite high. If the defendant appears in court as required, the bail will be returned at the end of the trial. However, if the defendant fails to appear, the bail will be forfeited to the court. Sometimes, a judge can order that only 10% of the total bail amount is required to be posted for the person to be released. A surety bond allows a bail bondsman to pay the full amount of the bail on behalf of the defendant in exchange for a fee. That fee is typically 10% of the total amount of bail, and the bondsman may require collateral to secure the bond. If the defendant fails to appear in court, the bondsman may be required to pay the full amount of bail to the court. Magistrate or municipal judges usually set bond on all initial charges except those carrying the potential for a life sentence or a death penalty. In these cases, bond must be set by a circuit court judge at a hearing that typically takes place during the next term of General Sessions Court in the county where the offense occurred. If a defendant violates a term of his or her bond, that bond can be revoked and the defendant forced to await trial in a detention center. Typically, a prosecutor or the bondsman who put up the money for the defendant will file for the revocation. However, the defendant is entitled to a hearing before bond is revoked. The judge making the ruling will typically consider the alleged violation and decide if it was willful. The judge can decide to leave the bond in place, add new provisions to the bond terms, or order the defendant to jail. Circuit court judges, at their discretion but at the behest of the defendant, may review and reconsider bond for General Sessions offenses set by lower court magistrates. They will also hear motions to revoke bond for General Sessions charges. In the next video, we will explain the purpose of preliminary hearings.